What does Chapter 7 bankruptcy consist of? Attorney Jackson Turner-Vaught says, a Chapter 7 bankruptcy case does not include the filing of a plan of reimbursement as in Chapter 13. Instead, the bankruptcy trustee collects and sells the debtor's non-exempt possessions and uses the profits of such properties to pay creditors in agreement with the requirements of the bankruptcy. Part of the debtor's assets may be subject to liens and mortgages that pledge the property to other creditors. Furthermore, the Bankruptcy Code will let the debtor keep some exempt assets, but a trustee will settle the debtor's residual assets. Accordingly, prospective debtors ought to realize that filing Chapter 7 may result in the loss of property. To meet the requirements for liquidation of debts under Chapter 7 of the Bankruptcy Code, the debtor may be an individual, a partnership, or a corporation or other business entity. Subject to the means test, relief is available under Chapter 7 regardless of the amount the debtor owes or whether the debtor is solvent or not. An individual may not file under Chapter 7 or any other chapter nonetheless if throughout the previous 180 days a previous bankruptcy was discharged by reason of the debtor's deliberate failure to appear before the court to comply with court orders, or the debtor willingly dismissed the previous case after creditors pursued relief from the bankruptcy court to acquire property upon which they hold liens. Moreover, no individual may be a debtor under Chapter 7 or any chapter of the Bankruptcy Code except when he or she has within 180 days before filing undergone credit counseling from an approved credit counseling agency. If a debt management plan is established in mentioned credit counseling, it must be filed with the court. For a free phone consultation, contact Attorney Jackson Turner-Vaught in Myrtle Beach, South Carolina, at 843-536-8386, or visit him on the web at www.tvbankruptcylaw.com.